I think, as we just heard from Andre and Dominic, we've got a fairly complex, fairly large package of reforms to deal with. Actually, I think as a bank, speaking about this package, we're spoilt for choice as the kind of issues we might want to raise. We have technical issues, we have thematic issues, and some of them have just been raised quite adequately as well. So I just wanted to say at the outset, before I make some comments on the proposals to start the debate, that we're a strong supporter of the further development of the recovery and resolution framework in Europe. It's to be applauded. We also strongly support the objective of implementing the TLAC standard and aligning Emerald. So the fundamental objectives of the legislation is something we're strongly supportive of. I wanted to take this few minutes I have at the beginning here just to highlight 4 areas of concern that we see with the package. They're not the only 4 areas, as I say. Plenty that we could go into. There's a long piece of work ahead as we get there, so I bear that in mind with these comments. We're only at the start of that process to a degree in lots of places. The first of those areas of concern is the new eligibility criteria for Emerald. The second of those concerns would be the absence of grandfathering provisions. The third would be overall calibration concerns. And the fourth we'd highlight would be the introduction of new tools like the moratoriums. So I'll just take those in turn, if I may, quickly. The eligibility criteria themselves, I think our major concern there is that we're seeing the introduction of criteria to facilitate bail-in and resolution that go beyond what we saw in the TLAC term sheet. We're seeing criteria in the case, for example, of the exclusion on including acceleration clauses in debt obligations to qualify for MREL that goes further than what's required in the US. So if you're in the US and you're trying to build your TLAC stack, you are permitted to issue TLAC, which has acceleration clauses in it relating to failure to pay, provided you have a 30-day grace period. So the Commission proposals are going further than that and excluding all acceleration clauses other than those triggering on insolvency. So that's an important change for us and reflects a change in the way we've structured our debt in the past. It's important to remember, I think, as well, that this rule was debated, these eligibility criteria were debated heavily in the US context as well. And if you look at the justification for the criteria in the US context, is justified on the basis that non-payment, acceleration on the grounds of non-payment, was not likely to be taken lightly by issuers. So these were most likely to occur immediately before the onset of insolvency. Issuers take non-payment of debt extremely seriously, so the risk of these occurring significantly prior to an insolvency event or a resolution event is seen as very low. So that's why in the US they decided not to take that journey. I think as well, worth bearing in mind the perspective of investors there in debt obligations, when we see alignment of the debt obligations with more capital structure-like instruments and the removal of safeguards and discipline imposed by covenants and such as failure to pay, that means they're fundamentally grappling with a different obligation to what they had previously. This will affect pricing, we think, although time will tell as to whether that's the case. We'd like greater certainty on this. We'd like it to be sorted out earlier rather than later, obviously, as I'm sure everyone would echo who's involved on the bank side. Another eligibility criteria that causes us concern is the requirement to have a contractual recognition of bail-in. We understand there's been some confusion there, certainly as to what that's intended to achieve, but we see it as fundamentally probably unnecessary in this context. We have statutory bail-in powers, and where the debt will be governed by foreign law, we have Article 55 to ensure that bail-in can be effective. So we don't see that as serving a real purpose. I mentioned one other very briefly, which was hotly debated at times in the council negotiations, which was the introduction of some form of cross-default or restriction on cross-default provisions. That would be extremely problematic for a lot of banks who have significant amounts of agreements outstanding that do allow for cross-default derivative agreements. So standard derivative agreements under ISDA Masters are a good example. So those are particularly problematic. I guess when thinking about eligibility criteria, though, the linkage that's most important is these are new criteria. They're, in the cases I mentioned, they're in excess of what the TLAC term sheet standard was. So they really do begin to underline and emphasize the need for grandfathering of existing issuance. And to my second point. And of course, banks have been spending the last 12 to 18 months issuing what we thought would be eligible TLAC and building up towards January 2019 on the understanding of that would be the case. So now we have significant TLAC in issuance and significant amounts of TLAC about to be issued, and certainly will be issued before the finalization of this package, which may not be eligible. So currently the package doesn't contain, or the proposal doesn't contain, grandfathering provisions to enable existing TLAC to be grandfathered. And we'd argue that grandfathering needs to apply to anything issued up to the date of the entry into force of the new package. And in addition, there should be, as there isn't, as is the case in the US, we wouldn't expect to see a sunset clause. So if long-term debt is issued up until the date of entry into force, be it 25 to 30 years, which is not uncommon, then that debt will remain eligible for its duration. So that's an important point to bear in mind. The third point I wanted to mention was to speak a little bit about calibration of Emerald generally. And this is more of an overall comment. We've seen, obviously, the SRB and national resolution authorities grappling with the first iteration of BRRD. In some cases, we've seen quite a sort of mechanistic approach to dealing with the amount of Emerald required, which, based on a sort of broad look across the market with some numbers that we've run, means that we've resulted in a situation currently where Emerald requirements in the EU and the UK are considerably more than those that we have in the US currently. So, we're talking about figures show a range of between 25 and 26% in the EU, 27 to 28% in the UK, but more like 23 to 24% in the US. So that needs to be borne in mind when we're talking about calibration of Emerald overall. I think it's an important point, the competitive advantage point here. And we'd emphasize that the concerns that are to some degree already reflected in the package, that the resolution authority needs to be consistently required to assess the resolution strategy of the firm, the size of the firm, the business model, the funding of the firm, and the overall risk profile. But we also need to keep asking the question, are those requirements in themselves? For example, we see, we're likely to see instances where banks in a pre-resolution scenario are suffering significant losses. There's likely to be post-resolution actions that banks take that reduce the size of the balance sheet, deleveraging and de-risking, and reduce the amount of RWAs on the balance sheet. So all of these factors need to be brought into account when that assessment is made, and we consider that to be an important criteria for the resolution authority to be held to at a level 1 level. The new requirements obviously have this Pillar 2 Emerald requirement, which is required, and more of hard guidance combined with a soft Emerald guidance component as well. I guess I'd query there whether soft guidance is going to remain soft guidance. It has potential, obviously, to be another additional add-on. If we look at the direction of travel we've had since the introduction of Emerald and the issuance that we've started, then it's been in one direction only. Is Emerald guidance another point at which we decide further conservatism is necessary, or will we reconsider the issues that I just mentioned? So I think that's a point for some concern and further attention as we move through the package. I'd just finish off very briefly with the mention of the moratoria, and there's a number of things that could be said about the moratoria, but I wanted to mention in particular that we've grappled with the issue of moratoria before. They obviously serve a particular purpose, and they, in some cases, that purpose is, particularly in the early intervention moratoria, that purpose is, it's to some degree questionable, I think. A 5-day moratorium at the point at which a pre-resolution point for the entity could indeed risk pushing the entity further towards insolvency and incentivize runs on banks. So those considerations obviously are being very seriously considered by some of my fellow panelists. But also I think with the technical amendments like this, we just need to have a broad consideration of other knock-on effects that may not be so obvious. For example, we went through this debate about moratoriums when we looked at stays. It was decided that 48 hours was an appropriate time period to primarily so that those stays didn't frustrate the regulatory capital treatment that banks enjoy in respect of netting and recognition of collateral, so that we have the ability to close out in a short time frame and value collateral and value derivative positions. Those are absolutely essential components of netting and collateral regimes that banks active in derivative markets rely on. So the interaction of moratoriums and those kind of capital requirements needs to be very carefully considered. So I'll conclude with those points. Thank you very much.